Court rise.
For judgment, Tribunal Bukrasu and Bra and another.
The reasons set out in our judgment which I'm handing down this morning, this appeal is dismissed. The appellant shall pay the respondent's costs of the appeal, such costs to be subject to detailed assessment if not agreed. The appellant's application for permission to appeal to the Supreme Court is refused. The stay of execution granted by the Court of Appeal on the 19th of December 2018 is lifted.
For appeal, SSC and others, and TP and another, and the Secretary of State for Works and Pensions.
Good morning, it's my lady. I appear for the Secretary of State on both appeals with my learned friend Mr. Anderson. Ms. Leventhal and Ms. Jones appear for the claimant, and Mr. Butler appears for the Equality and Human Rights Commission.
Thank you.
Can I check, my lord, that you have everything? I know that there was some muddle this morning about supplementary bundles.
Yes, thank you very much. I have everything. I believe everybody else has everything.
I believe so.
Yes. We have two. So we have the core bundle, two supplementary bundles, and two bundles of authorities.
Very good. Well, in that case, let me tell you what I'm proposing to do. I will start by addressing you on TP number 1, the first appeal, and the structure of my submissions is going to be as follows. First of all, I'll take you through some relevant evidence and parts of the judgment which we say provide critical context for the grounds of appeal. Then I'll start off by addressing you on ground 2 of the appeal, which is status. And then I will be addressing you on differential treatment, which is ground 1, and justification, ground 3, together. As you may have seen from the order of Lord Justice David Richards giving permission to appeal, the judge there considered that some of the submissions on differential treatment and some of the submissions on justification effectively ran together, and that ground 1 might merge into ground 3. And I agree, and respectfully think that they are two sides of the same coin, so it would be sensible for me to address them together.
Thank you.
Then, very briefly, I will address you on ground 4, the terms of the declaration. Then I will be coming to the assertion that the Secretary of State has breached the duty of candour. And then I will be addressing you on the claimant's assertion that the appeal in TP number 1 is academic. I'm not sure how strongly that argument is pursued, but I ought at least to address it briefly. And finally, I'm going to address you on the cross appeal, the Miscellaneous argument, which we say is wrong. So, my lord, that sets out my structure. If I can start with the first of my various headings, which is the background and some parts of the judgments we say provide important context.
Yes, I just if it would be of any help. So obviously we've read the scope and arguments of the two judgments and the interveners' submissions as well, written submissions. I don't think we need, it doesn't sound you're going to do this, but we don't need to be taken at this stage in detail through all the regulations, all the statutory provisions, unless there's something specific in the course of your argument that you want to refer to, because we understand what the, in general terms, what the structure of the statutory and legislative provisions are.
Yes, I wasn't planning to do that, my lord, but I'm to the Secretary of State in TP1. And that's in your first supplementary bundle, tab 15, starting at page A227. And I want to pick it up at paragraph 84 on page A252. Now at 84, my lord, Miss Young quotes debates in the House of Lords precisely on the effect of removing SDP I hope you don't mind if I refer to SDP and EDP throughout my submissions. SDP for disabled persons without carers. And one sees, starting at paragraph 84, that there were questions on this from Baroness Thomas and Baroness Tyler, and a response by Lord Freud quoted. And at 87, there is an amendment tabled in December 2011, and one sees this at the top of page A258, to put an additional element into the amount of universal credit that's payable for those who are severely disabled and have no one receiving either carer's allowance or carer's premium, in essence seeking to recreate the current SDP within UC. And Lord Freud makes the point below that that would cost an extra 400 million, which he said was unaffordable.
So where have we got now? A257.
I'm looking now, my lord, at the top of A258. And that quotes Lord Freud dealing with the proposed amendment. And the amendment, a couple of reasons why that is not going to be government policy, he says. He says it would require an extra, it's not intended as a cost-saving measure in general. We're redistributing around 800 million of current spend without returning any savings at all, of her statement. So now, and at paragraph 93, she introduces the proposition that there's a need for introduction in a phased manner rather than on a big bang approach, using a test and learn approach. And she sets out at 94. At 95, the summary is, it's not therefore administratively workable for universal credit to be introduced overnight. Transition distinction between natural migrants and managed migrants. And distinction in her view number one, at least until the matter came before the judge. The claimant's argument, it wasn't at that point based upon a comparison between those who migrated and those who didn't, let alone upon cohorts of people who moved local authority. After 98, she explains that a change of circumstances is viewed as a new claim, and there's no sense in having a new claim. Explains the government's policy as to the difference between managed migrants and natural migration in terms of protection. And it's not put in quite this way, but the point is, if a claimant is being forced to do something when they're making a choice, so in other words, if they naturally migrate because there is a change of circumstances. Paragraph 100 refers to policy briefing notes that contain the government quoted that claimants who come onto universal credit as a result of a change of circumstances will not be entitled to transitional protection, whereas managed migrants will be. And it may just be helpful just to turn that up. If you are able to keep a finger in the witness statement, I can ask you to do that, and just to flick forward to page 51C from paragraph 1, transitional protection for people whose circumstances stay the same. And the important point here is that the transitional protection policy did not apply to natural migrants because those were viewed as people whose circumstances did not stay the same. Coming back to Miss Young's witness statement, my lord, paragraph 101. At 101, she points out that the top-up commitment challenged by the claimants, so the top-up commitment to managed migrants, that doesn't yet apply because there aren't any managed migrants at the point that this claim is being decided. And starting at 102, she deals with what amounts to a change of circumstances, which mean that you're a natural migrant. One example is moving between local authority areas. Paragraph 103 makes the point that SDP claimants are less likely to change circumstances, they're less likely to be natural migrants. And paragraph 104 refers to a non-exhaustive list of what could be a change of circumstances triggering the need for a new claim. And that, again, is a cross-reference to the document I've just taken you to, starting at A517A. And it may be useful, again, keeping your finger in the witness statement if you would, to go to A517E and have a look at a non-exhaustive list of the sort of circumstances that could trigger a new claim and therefore make you a natural migrant. And as one sees, there's a wide variety of circumstances that could do that. One of which is a change of address, point 10, change of address for housing benefit claimants who change address across local authority boundaries. But equally, because one is dealing with a large number of legacy benefits, 6 legacy benefits, which might be claimed or not in a variety of different circumstances, there are a whole set of different circumstances that could amount to a trigger. And if the principle is that a new claim for a legacy benefit is a relevant change in circumstances that connotes natural migration onto universal credit, and there are 6 legacy benefits that universal credit is replacing, it's unsurprising you say that there's a very complex set of circumstances for you just to see how this works in the legislation. And this is the only bit of the legislation I'm going to take you to on TP number 1, I think. But if you pull out the first bundle of authorities and turn up tab 7,
I've extracted some for you, so can you tell me what you're looking at? So
yes,
I have no different
this is the Transitional Provisions Regulations from 2014.
Right, thank you.
So, if one goes to Regulation 5, you'll see that by 5.1, that is the exclusion of 4 existing benefits where a claimant is entitled to universal credit. And I should just note, and you see it from footnote 1, that job seekers allowance and old-style employment support allowance are separately dealt with, but I don't need to take you to that. Then Regulation 6.1 says that except as provided for in paragraphs 5 to 9, which again I don't need to take you to, a universal credit claimant may not make a claim for income support, housing benefit or a tax credit. And then under 6.2, one sees the person as a universal credit claimant if the person is entitled to universal credit. Over the page, 6.3a states that for the purposes of paragraph 1, a universal credit claimant, so a person who's entitled to universal credit, makes a claim for benefit mentioned in that paragraph if the claimant takes any action which results in a decision on a claim being required under the relevant regulations. And one sees that the relevant regulations from subparagraph 4 include, if one just focuses upon housing benefit, by 4 the relevant housing benefit regulations. So in other words, if something happens that, and you will appreciate, my lord, that the first element of, first relevant element of this claim was a straight challenge to the manner in which the disabled are catered for under universal credit. And Mr. Justice Lewis defines that, or sets out a précis of that challenge, paragraph 46 of the judgment. And there are essentially two sub-issues. One is differential treatment between the person with severe disabilities and a carer, and the person with severe disabilities without a carer. And the second
of the issue, that doesn't seem to be, as it were, a full-scale attack on the very concept of moving someone from benefits to universal credit.
I think that's absolutely right, my lord, as far as ground one goes. I mean, ground one, you will appreciate, focused upon the fact that SDP was paid to people without carers. In fact, under the new system, there's a carers allowance within universal credit, but there's not a replication of SDP. So it's said that people who don't have carers are put at a disadvantage. It may, you've got to treat people with different levels of disability differently, and universal credit treats them in the same way. And therefore, that system, as regards people with disabilities, is unlawful. And in my submission, that is indeed a general challenge to the regime. Now, the judge approaches that issue both by reference to a straight test of whether the measure is manifestly without reasonable foundation, and I hope you don't mind again if I say MWRF throughout these submissions, because I'll be repeating it quite a lot, and by reference to the structured Tigeri approach. And if one comes to his conclusions, the first sub-issue, so the differential treatment between severely disabled people with carers and those without carers, is dealt with starting at paragraph 62. And what the judge says there is, well, there's been a considered view taken by the legislature that there should be a higher level of support for those with disabilities generally, so a greater level of support than the previous basic amount of employment support allowance catered for, which was payable to those with a limited capacity for work or work-related activity. But what there shouldn't be is additional components equivalent to SDP or EDP within universal credit. And at the end of 64, one sees the judge saying, well, that reflects the view of the decision maker. It's desirable to encourage people to act as carers and provide them with financial incentive to do so. Those without carers will not receive, as they formerly did, additional disability premiums in the form of SDP, which they could have used to purchase care. That, however, reflects the view that such disability premiums were not an appropriate mechanism for targeting support to those with such disabilities. And he to say, well, that approach is justified both on the paragraph 68. There is what we say is an important observation for the purposes of this appeal, starting in the middle of the paragraph, where the judge says the claimants and others are seeking an allocation of resources to assist with their needs. They're not entitled to insist upon the continuation of the previous level of resources they received under a previous system, particularly where that system is considered by government and the legislature to be unduly complex and not to achieve the appropriate aims of a welfare benefit system in the present day. In all those circumstances, the 2030 regulations do strike a fair balance in the way that it deals with needs arising out of disability and the community interest. Now, moving on to the second sub-issue, so the Miscellaneous challenge, that is...
Sorry, just before you do,
yes, indeed.
Can we just note paragraph 69?
Yes, yes. Then paragraphs 70 to 73 deal with the Miscellaneous challenge. that too is rejected. And the essential reasoning, we say, is in the middle of 71, that the criteria identified under the previous regime don't define an objectively ascertainable factual state of affairs, which must similarly be accommodated by any replacement system. And at 73, the judge says, well, the decision to pay a higher allowance to all persons with a particular level of disability, which is what's happened under UC, is objectively justifiable. Actually, I'm so sorry, my lord, it may be best to pick that up at the middle of 72. So one sees him saying the previous disability premiums were seen as complex to administer. For the reasons discussed more fully above in relation to the first aspect, any differential treatment arising out of the fact that claimants now receive the same level of benefits for disability, whereas formerly different groups received different benefits, is objectively justifiable. It's not manifestly without reasonable foundation. Adopting a different measure would be seeking to achieve a different aim, and that's at the end of the paragraph. Now we say it is critical that these are unappealed and clear findings of the judge, that the new system itself does not breach Article 14 as concerns the treatment of disabled people. And one then comes to implementation arrangements addressed from 75 onwards. Now just at this point, if I may, I'd like to pick up 80 and 81, so I'll come back to their implications later. But at 80, the judge records the legitimate aim of seeking to implement universal credit and says the need for a phased transition arises out of the need to test computer systems to train a very large number of decision makers, the need to address problems as they are identified, and the benefits of publicising the system to claimants as it is gradually introduced. All parties accept the legitimacy of a phased transition from the existing benefits to universal credit. I agree that the aim of achieving a gradual phased introduction of universal credit is a legitimate aim, and I further agree, and we say this is important too, that it is legitimate to identify the fact that one aspect of the assistance needed, such as assistance with housing costs, is an appropriate trigger to move a person from the existing benefit system to universal credit. So there we have the clear findings that new system is justified, it's necessary to move towards it in a phased manner, and in principle a change of circumstances is an appropriate trigger for such a move. And if I can flag up now the main submission I will be making on objective justification in light of those findings, it is this. Given those findings, we say it cannot logically have breached Article 14 to move persons onto universal credit when their circumstances changed, simply because no transitional protection was provided. Because the relevant difference here, the relevant difference in treatment, is simply the difference between what you get under the old system and what you get under the new system. In circumstances where the new system is justified, saying that there's been a breach of Article 14 because no transitional protection has been given is effectively using the non-discrimination duty in Article 14 as a proxy for a duty to make reasonable adjustments in the form of protection payments.
Could you just say that last bit again? The fact that no transition
Yes,
protection
my
is
lady.
given.
essentially, in circumstances where you have found that the new system is lawful and justified for the purposes of
Yes.
as a proxy for the duty to make reasonable adjustments in the form of protection payments. And we say not only is there no case law from Strasbourg suggesting that such a duty to provide transitional protection could arise under Article 14 in these circumstances, but all the relevant Strasbourg case law, and I'll take you to it in due course, on changes in welfare regimes is completely to the contrary. So that's my headline submission. I'll obviously be expanding upon that in due course. My lord, those are the...
Forgive me, Mr. Milford.
Yes.
Can I just flag up? Don't answer this now, because it's absolutely at the core
Yes.
of your submissions. So please return to it at the appropriate juncture. But isn't the point the judge is making simply this, that in general, as a matter of principle, there may not be a duty on the state to provide any kind of transitional protection? But when you have transitional arrangements, you've still got to comply with Article 14. And if there is then, in the way in which you make the transitional arrangements, if there is an Article 14 problem, then that needs to be objectively justified. And the particular thing that he focused on, rightly or wrongly, the particular thing he focused on was that if you continued to have housing needs but remained, you moved home, but you remain with the same local authority area, you don't need to go to UC. Whereas if you cross a local authority boundary, you are compelled by the legislation to apply for UC. Is that right?
Yes,
So,
indeed.
that's what he was focusing on.
yes.
I don't think he was saying, correct me if I'm wrong, that there was some kind of obligation to make transitional protection. Because the legislation could presumably have said that if you move home, but within the same local authority area, you've also got to apply for UC. It could have said that in principle. And if it had, the discrimination identified simply wouldn't have existed.
Well, my lord, I will come to this in due course, because as you rightly said, it is at the heart of our submissions. But I think that for present purposes, actually, the real answer is to look at what is the difference in treatment that needs to be justified, to analyse that correctly, and once you have properly analysed what the different treatment is, and we say, on a proper analysis, the different treatment is simply the difference between regime A and regime B,
I see.
then the question whether it's justified flows from that. So, my lord, the second topic to which I'm going to turn is the question of status. I'm going to start with status. And status is defined by the judge at paragraph 78 of the judgment as those previously in receipt of basic allowance and SDP and EDP who move house to a different local authority and those who move house within a local authority. And we say there are two principal problems with that definition of status. They may have arisen from the fact it is a new comparison not made in the claimant's grounds, so formulated by the judge, so that perhaps there is not a sufficient chance to sort of flesh out what the problems were. But the first problem is this, that the difference between the two cohorts in terms of status consists entirely in whether or not, when they move house, they do so across a local authority boundary. And we say, whether someone does or does not move across a local authority boundary is too tenuous to constitute a status for the purposes of Article 14. It's about what someone does, not what they are. That's the first problem, we say. And the second problem is that it amounts to defining status solely by reference to the treatment complained of. In this case, having a rule that differentiates between people based upon whether they make a new housing benefit claim or not. That remains a principle of domestic law. We say that you can't define status solely by reference to the treatment complained of. And we say, in effect, that is what has happened here.
Sorry, can you please repeat the formulation of the treatment complained of? That second proposition.
Yes. So, I'm sorry, my lord, do you want me to repeat what I say the second problem is?
Yes, you said that
yes.
you define
we
it
say
solely
that,
by reference to treatment complained of, which is?
In this case, it's having a rule that differentiates between people based upon whether they make a new housing benefit claim or not. That's what the differentiation is about.
Is that right, isn't it? Because they've moved across a local authority boundary.
Well, that actually comes back to whether the judge was quite right to define status in the way that he did, my lord. And TP's circumstances are themselves an indication of this, because TP was living with his parents in Dorset, and he then moved to London and made a new housing benefit claim, and because he made that claim, that triggered natural migration. But in fact, if he'd stayed within Dorset and made a housing benefit claim, that would also be a new claim because he was previously living with his parents. So actually,
So he wasn't previously making a housing benefit claim at all?
Indeed, my lady. He had, and historically he made a housing benefit claim. He then moved in with his parents, and then he moved to London. But the real authority boundaries as a proxy for that, in essence. But it needn't be.
Dorset and already receiving housing benefit. If you move house within Dorset,
There would have been a trigger event in TP's case is because he wasn't previously in receipt of housing benefit.
I
But
see.
it does indicate that
Yeah.
this is actually about new claims, not
If you
about.
were in, you would also have to move to universal credit.
So the trigger event which causes the trigger event to occur.
Upon was the difference between different categories of long-term prisoner, the more than 15 years and less than 15 years categories. And there are two relevant aspects to the reasoning that I need to pick up. One is in Lord Bingham's speech at 28. There he says, "I do not think that a personal characteristic can be defined by the differential treatment of which a person complains." And to the same effect, one sees that point also made in paragraphs 45 and 47 of Lord Hope, for which a person complains. So that's the first.
Was that part of the essential reasoning?
Indeed, my lord, it is part of essential reasoning, yes. And the second is that status generally requires concentrating upon what a person is rather than what he does or what is done to him. And one sees that in Lord Hope's speech at 49. And Lady Hale at 62. It's the end of 62. Now, those two strands of reasoning are both picked up in RJM, which is the next case that I want to take you to, which is tab 19. And there, Lord Newburger's speech represents the unanimous view of the House, and if one picks it up at 45 to 46, at 45, he says, formulations are dangerous. I consider that the concept of personal characteristic, not surprisingly, like the concept of status, generally requires one to concentrate upon what somebody is rather than what he is doing or what is done to him. The reference to personal characteristic is a reference back to Kjeldsen in the European Court, which says that Article 14 is about personal characteristics. Such a characterisation approach appears not only consistent with the natural meaning of the expression, but also with the approach of the European Court and of this House to the issue. And then at 46, this is also consistent with what Lord Bingham of Cornhill said in Clift, namely that he did not consider that a personal characteristic can be defined by the differential treatment of which a person complains. Now, as it happened in RJM, what this all led to is a finding that homelessness was a relevant status because it was an acquired personal characteristic. But it's the reasoning upon which I need to focus. So there one has those two strands of reasoning that I've identified. You focus upon what someone is, not what they do, and you can't define differential treatment in terms of, you can't define status in terms purely of the differential treatment to which the person claims. Picked up unanimous view of the House of Lords in RJM. The next step in the analysis is Clift against the United Kingdom, and that is tab 45, so the second bundle of authorities. This was Clift in the House of Lords when it got to Strasbourg. And they say that the difference between a prisoner sentenced to less than 15 years and more than 15 years, the difference between those two categories of extended determinate sentence, is a status. And one sees the essential reasoning for that at paragraphs 59 to 60, and perhaps rather than reading them out myself, I could just ask your Lordship, my lady, to read those paragraphs. So really the first point is a personal characteristic doesn't have to be innate or inherent, and they say they're not persuaded that the treatment of which the applicant complains must exist independently of the other status on which it's based. So, in other words, they disagree with that aspect of the reasoning that one sees in the House of Lords in Clift and in RJM.
So just wait a second, please.
Well, you drew out from the two authorities you mentioned 2 points. One is that status can't be defined by reference to the treatment of which you complain. That's the first point. And the second one is you can't complain that there has to be something which is personal to you, a characteristic, as opposed to
It's about what you are, not what you do.
it's not about what is done to you.
Yes.
That was the second
Indeed,
point.
yes.
It's not something which is done to you. It has to be something else.
Yes.
Now, this authority would seem to be contrary to both those points.
It's certainly contrary to the first point. Whether it's also contrary to the second point, I think, is a bit more debatable, because it doesn't do away with the need for a personal characteristic. It just says it doesn't need to be innate or inherent. But my Lord, what I'm going to do is I'm going to come to how that's dealt with in the subsequent, because Clift is obviously considered in subsequent case law of the Supreme Court, and I'm going to take you to what the Supreme Court has said about it shortly.
But in this, just so I've got this right, because we went through this quite quickly, in the Swift case, the complaint was what about the treatment depending upon the sentence? Is that right?
Yes, that's right.
And so the question was whether the treatment by virtue of the sentence was a sufficient character, a sufficient status.
Whether being a prisoner who had been sentenced to an extended determinate sentence of over 15 years, as opposed to being a prisoner who'd been sentenced to one of under 15 years, was a sufficient status. That's the way in which the
So that didn't depend in any
distinction
sense on a personal characteristic at all.
didn't depend on anything innate or inherent.
Anything outside the sentence.
Well, it may have depended upon one thing which is drawn out in subsequent case, which I'm going to take you to, which is the dangerousness of the offender. But that doesn't particularly appear, I acknowledge, from the European Court's decision in Clift, and that's why I think I need to take you to the subsequent decisions of the Supreme Court.
I'm sorry to press you on this because I want to understand this.
Yes.
We identified the two separate elements for status,
Yes.
or non-status as it were, or
Yes.
don't qualify. Can't define status by reference to the treatment for which you complain, and it must be, it can't be something that's done to you. Which of those do you say survives this decision of Strasbourg?
Well,
Which of those two survives?
I actually say that both of them survive, and the reason why I say both of them survive is apparent from the subsequent Supreme Court case law. But what I'm doing now, my Lord, is to take you through a series of cases where you have a clear line of House of Lords authority. You then have a case in Strasbourg that goes against it, and you then have a consideration of what difference Strasbourg has made
So
in
the short
subsequent
answer
cases.
to my question then is, notwithstanding the Strasbourg decision,
Indeed.
both survive.
Indeed.
All right.
Yes.
But when you refer to the status being determined by the difference in treatment, I mean, here they were discussing whether the status of a prisoner who was sentenced to more or less than 15 years, because 15 years was the cut-off or was the criterion which determined the treatment. If the treatment had differed according to whether the prisoner sentenced for 15 years was a status, they would have been considering whether being a prisoner who had been sentenced to 10 years or 17 years was a difference in sentence. So the question is really, is there a status, does the for drawing the distinction or not? And here they seem to be saying no. Presumably it follows from Clift that if it had been a difference based on whether he was convicted, sentenced to 10, the distinction is parasitic or derives from, to use a neutral phrase,
I think
from
that
the
may well be
criteria.
right, my lady. And actually, what I think I need to do is to show you why those propositions do nevertheless survive on the basis of the subsequent Supreme Court line of authorities. So, the effect of Clift against the UK, a fourth section's decision in Clift, and I should take you briefly to each. So, if I may, I'll start with Mattison, which is tab 22, the authorities number. Patterson was about, and because he'd been an inpatient for more than 84 days, his disability and living allowance was suspended. And he brought the Article 14 claim on the basis he was being treated less favourably than persons with severe medical conditions who weren't required to spend a lengthy period in hospital because they would continue to get the allowance. The Supreme Court found that he did have a relevant status, and the essential reasoning is in Lord Wilson's speech, starting at paragraph 20. So he says, well, this status, a severely disabled person who needs to spend more than 84 days in hospital appears contrived, but does it pass muster? And at 21, one sees that he cites Lord Neuberger in RJM and his suggestion that status generally requires consideration of what somebody is rather than what he's doing and what's being done to him. So that's 21D. And then says, well, by its decision in the RJM case, the House of Lords demonstrated that the prohibited grounds extended well beyond innate characteristics. So doesn't dissent from the fact that you need to concentrate on what somebody is, but qualifies it by indicating doesn't need to be an innate characteristic. And refers to Lord Walker in RJM, and I didn't take you to this, but Lord Walker, in agreement with Lord Neuberger, he offered the simile of a series of concentric circles, so you have core status in the first circle, gradually moving outwards, and the closer you are to the outer bounds, the less is required by way of justification. At 22 of his speech, Lord Wilson addresses Clift and refers to that as an indicator that if the alleged discrimination falls within the scope of a convention right, the Court of Human Rights is reluctant to conclude that nevertheless the applicant has no relevant status, and one sees that at little d on the following page. So now paragraph 22d. At 23, he poses the essential question, and it's just by F. Why should discrimination, if such it be, between disabled persons with different needs engage Article 14 any less than discrimination between a disabled person and an able-bodied person? So that is the point that he's making. He's saying, well, as a disabled child in need of lengthy inpatient hospital treatment, the claimant had a status, and that status was different from that who didn't, from someone who didn't have those same needs and didn't need to spend as long in hospital. So there are two observations about that reasoning. The first is that that is not a difference that is defined solely by the treatment complained of, because the comparison that Lord Wilson is making is between children with different medical needs.
So that is not a difference defined solely by
the treatment, because the comparison is between children with different medical needs. That is his. That's the question. Why should discrimination between disabled persons with different needs engage Article 14? That's his rhetorical question. And the second point is that the reasoning is indeed about what the claimant is, not simply about what he does. In other words, he is a child with particular, very serious medical needs.
I'm not quite
quite sure. I thought what you're doing now is explain how the 2 points that you got from Lord Newberger and other, the RJM case, how they persisted. But I don't see how you show they persist merely because it wasn't necessary to, as it were, to deal with those. I mean, in this particular case, there was something innate, but that doesn't mean to say that the points that those points subsist after the Strasbourg case. There's no logical connection.
Indeed, my lord, I fully accept that, but the reason that I'm taking you to this is I'm showing that my 2 points are not necessary for the decision. I'm now going to take you to another case called Doherty, where you will see that actually the treatment must not be solely defined by, status must not be defined by treatment, does exist.
Right. But this, I don't see myself at the moment how this case helps you.
No, I'm making the point it doesn't hinder me, I think, my lord.
It doesn't hinder. No, it doesn't hinder you. It doesn't say one
Because, and I make that point because Matheson is cited against me as a case that effectively does away with my argument on status. So I'm now making the point to you that it doesn't.
I see. Right.
Now the next case that I want to take you to, my lord, is Doherty, which is tab 26. And this is a case where an Article 14 claim was mounted on the basis that an earlier, harsher sentencing regime was applied to the defendant. The person convicted of an offence after the 3rd of December 2012 wouldn't have been subject to an indeterminate sentence of imprisonment for public protection, and because he was convicted before the 3rd of December 2012 when a different legislative regime applied, he was subject to that sentence. And the only recent decision in Doherty is given by Lord Hughes, and he deals with Article 14 discrimination at paragraph 63. So it sees at the beginning of paragraph 63 the other status relied upon. So status as a convicted person prior to 3rd December, or status as a prisoner who is subject to an indeterminate sentence. Then he says, assuming for the sake of argument that status as a prisoner subject to a particular regime can in some circumstances amount to sufficient status to bring Article 14 into question, see Clift against the United Kingdom, it cannot do so if the suggested status is defined entirely by the alleged discrimination. And he says, well, that wasn't the case in Clift.
Is that right? And what's your submission? Was that or was that not the case in Clift?
Well, I think it wasn't the case in Clift, my lord, because as one will also see from Stott, that in fact that the status is also has an aspect of your dangerousness within it. So,
I go just read this again, please.
clear ratio. This is a matter of domestic law. You cannot have status that is defined entirely by the alleged discrimination. And that is, I think, all that I need to take you to from Doherty.
Would your submission go this far, Mr. Milford? Even if, I'm not saying
Yes.
this would be our view, but even if we thought that Lord Hughes had misunderstood or misstated the true position in Clift, it doesn't matter, because we're bound by the ratio of what the Supreme Court has said, and would you say that that's irrespective of how we might analyse a decision of the Strasbourg Court, because we're bound by decisions of the Supreme Court, not by decisions of the Strasbourg Court?
That is exactly what I would say, my lord. That is exactly what I would say. finally, in the line of Supreme Court cases, there is Stott, which is tab 34 of your authorities. Now, Stott revisits a Clift-type question, if I can put it that way, because the question is whether the prisoner serving an extended determinate sentence has a relevant status, as opposed to a prisoner serving any other type of sentence, because a prisoner with an extended determinate sentence would only be eligible for parole after 2/3 of their sentence, and the prisoner in another category would be eligible after half of their sentence. And in the result, it departs from Clift in the House of Lords. So there is a finding that the prisoner in Stott does have a relevant status. There are a number of, it's not particularly easy to analyse, but a number of different strands of reasoning. And with apology, I think I need to take you through them as briefly as I can. Lady Black analyses the case law in the most detail, and it may be helpful for you just to note that she sets out a series of propositions at paragraph 56 of what she says had been decided at the time of Clift in the House of Lords, so propositions 1 to 7, and she says what she thinks has happened to those propositions. It's paragraph 63. For my purposes, you can see that she says proposition 4, which is personal characteristic could not be defined by the differential treatment to which the person complained, lives on in the Crown against Doherty, but perhaps needs to be considered further. And proposition 6 is what I've said is, it's about what you are, not what you do. And she says here, it may not be helpful to pursue it in the abstract, whether it assists will depend upon the facts of a particular case, and one sees that at E, paragraph 63E. So not rejecting it as a proposition, but saying will rather depend upon the facts of the case. And her conclusions on status start at paragraph 70. At 72, she makes the point that my Lord Egerton has picked up with me, that the clearest difference is in relation to whether the treatment of which the applicant complains must exist independently. And she says, and I'm paraphrasing, that essentially she says, well, I think that there are problems with the concept, and I would be cautious about spending too much time upon an analysis of it. See paragraph 75. But
So she
nevertheless,
does seem to be questioning, I think, doesn't she, Lord Hughes's analysis?
indeed, my lord, she is
says
questioning.
she's
Lord
questioning
Hughes's
it,
analysis.
whether
that is correct.
whether that is consistent with the Strasbourg decision.
Questioning it, but I say not overruling it, departing from it, questioning it. At 77,
Sorry, in 75,
Yes.
it may be important for us to note the last two lines of page 1856 and the next page. In any event, it can properly be said that the status upon which Mr. Stott relies exists independently of his complaint. So, I mean, what's your submission about this? That there's nothing in binding ratio in what has just gone before anyway. Is that right?
yes, that is exactly my submission, my lord. And at 77, E, one sees the point that my Lord Justice Singh has put to me. You see, what she says is, putting it another way, what Mr. Stott did has led to him receiving an extended determinate sentence, but once imposed, that extended determinate sentence exists independently of what he did. So she says that it's an acquired personal status in essence. And this comes to the second of the two propositions. Status is about what you are, not what you do or what you have done to you. She's saying, well, that principle is not going to prevent Mr. Stott from having a status. This particular sentence.
Well,
And
I don't want to interrupt you at all, but the sentence of IPP, imprisonment for public protection, no longer existed after the 3rd of December 2012.
extended determinate sentence
Yes.
has a different status from someone who isn't serving that sort of sentence. So
I
it's
see,
not.
right.
And
I don't know, it seems a bit, it's not straightforward.
it's not straightforward. My gosh, it's not straightforward. And the essential.
The point is that, I'm so sorry, because I'm trying to understand.
So,
So, my lady's correct in the sense that one of the distinctions here was that an offender serving an extended determinate sentence only became eligible for release on parole after serving 2/3 of the appropriate custodial term, while other prisoners serving determinate sentence became eligible after serving half their sentence. And then further, prisoners serving discretionary license became eligible for parole after serving a specified minimum term. And the problem is that what seems to have happened here, looking at Lady Black, she seems to be making a distinction, as I understand it, between the sentence itself and the implications that went with it, which is a really refined distinction, they say so. Whether you describe that as the same thing as what you're complaining or something different seems to me to be very much a matter for debate. But that's what she's doing.
That's what she's doing.
She's making that distinction.
That's right. And the essential ratio is paragraph 81. That's pulling it together. Grounds to be given a generous warning. Bear in mind the warning of generous warning. Bear in mind the warning of the European Court is need for careful scrutiny, lest they encounter. And considering all the case law, I will conclude that the difference in the treatment of extended determinate sentence prisoners in relation to early release is a difference within the scope of Article 14. So that, my lord, is Lady Black. is in the minority. He actually says that that there is no status here, because he thinks that being an extended determinate sentence prisoner is indeed about what he did, not about what he was. So that's paragraphs 160 to 161. But on this aspect, he's in the minority. Lord Hodge, his reasoning is at paragraph 185. And he agreed about his basis for doing that at 185. And if I can paraphrase, that is essentially on the basis that other status is not to be interpreted narrowly, and the weight of authority supports Mr. Stott having status. So, and I say that is all uncontroversial, but of limited purchase for our case. Lady Hale if I can pick this up, she starts by saying status is clearly intended to add something to the requirement of discrimination or a difference in treatment. Otherwise, Article 14 would simply have said that the enjoyment of the Convention right should be secured without unjustified discrimination between persons in an analogous situation. So it can't simply be ignored, even if you have to interpret it broadly. That's 209. In 210, reiterates the principle that status must not be defined solely by the difference in treatment complained of. And she says that actually, example of that happening, even though the European Court rejected the proposition put to it by the UK government. And at E, 210E, one sees that. That, it seems to me, is the true principle. The status must not be defined solely by the difference in treatment complained of, for otherwise the words on any ground such as would add nothing to Article 14.
As I read that paragraph, I think that was her explanation of Paulik and Slovakia.
Yes, she says that Paulik and Slovakia is not really authority for the proposition for which the European Court cited it.
Yeah.
Yes.
I may have misunderstood what she was saying. I didn't read her to say, as I think you've just submitted, that she was saying that Clift was such a case. I think what she's saying is that the European Court's reasoning is, at least to an extent, faulty, because they cited Paulik and Slovakia, but it wasn't a good illustration of the proposition they were advancing for two reasons. And then she sets those two reasons out.
My Lord, and apologies, that is absolutely right, and I'm sorry if I...
No, that's
yeah.
right.
But what she does do in my submission is reiterate the principle at the end of the paragraph.
That I understand. But does she say anywhere whether she takes the view that Clift in Strasbourg has in fact disposed of this point, or is she saying that we're still back where we were with Clift in the House of Lords, or doesn't she say?
She doesn't say that Clift and Strasbourg has disposed of this point. And in my submission, nor could she, in light of the Supreme Court case law, Doherty, etc.
Well, I think there is a difficulty here, because she starts off in the first sentence in 210, saying that the court, she quotes it, court has declared itself not persuaded that the government's argument treatment which the applicant complains must exist independent of other status. And then at the end of that paragraph, she says the true principle of status must not be defined solely by difference in the treatment complained of.
Yes, I mean, my Lord, what she does is she says... she says, Strasbourg said this, they relied upon Paulik. Actually, Paulik is not authority for the proposition for which they cited it.
Yes.
And then, at the end, yes, I do think it is a true principle. You do have to have status that is not defined solely by the difference in treatment complained of, because otherwise the words of Article 14 itself would be nugatory.
As I read this, I think she's saying the point was not decided in Cliff. I think she's putting the words "not persuaded" that are not a definitive statement. That's what it looks
That may
like to
be.
me.
Yes.
You mean not persuaded that something's wrong is not the same as deciding it's right?
But I think that's what she's saying, effectively, because that otherwise they're irreconcilable, those two propositions. At the moment, it seems to me.
Did Clift win his case in Strasbourg?
He won his case in Strasbourg.
And then he lost his case in the House of Lords. So it seems to have been quite an important difference of reason.
Yes. Yes, maybe it is. And just to finish off with Lady Hale's reasoning, what she says is, yes, we've got this principle that status mustn't be defined solely by the difference in treatment, and she also says that that doesn't apply to Mr. Stott, because you've got a clearer difference here than you had in Clift. And one sees that at paragraph 212. In fact, towards the end of that paragraph, she says, the status, in effect, she says, the status could lie in the different criteria for the imposition of each type of sentence, which concentrate upon the dangerousness of the offender, itself a personal characteristic. So that's how she's dealing with the question of, is it about what you do or have done to you, or is it about what you are? And she says, actually, dangerousness is, whether or not it's an acquired personal characteristic or an inherent personal characteristic, that is at the root of the distinction.
But how can that be the case when, even, as I understood it, even someone who was as dangerous as Mr. Stott after the cut-off date would be sentenced to a different sentence, which would not deprive him of parole? Wasn't the distinction between two people who are equally dangerous?
My lord, my lady, I think that may be going back to Doherty.
Oh, right, am I getting mixed up? Okay. So what was
Stott is a distinction between prisoners who at least putatively have different levels of dangerousness.
Okay.
And
This relies on the concept of dangerousness being an inherent characteristic, and degrees of dangerousness being an inherent characteristic. Is that right? As opposed to actually acting in a dangerous way.
that is the line of reasoning that Lady Hare is following, my lord, and maybe the type of dangerousness at issue in Mr. Stott's case, which is an extreme type of dangerousness connected with terrible offences against children, was indeed, that might explain why she comes to the conclusion that dangerousness is something personal to who you are in this case.
Yes, as I understand it, I may be wrong, I think one of the complaints being made in Stott was the contrast between how a determinate sentence prisoner is treated as distinct from someone who has an extended determinate sentence,
Yes, indeed.
which are two different kinds of sentence. And what the legislation, by the time at least that this case arose, had done, the legislation had been amended so that in relation to determinate sentence prisoners, as has been the case for many decades, there's automatic release at the halfway point. But is this right that in Mr. Stott's case, that had been changed by the time he gets his sentence, and so that the release is only at the 2/3 point? And I think even then, only if the parole board consider your case and decide that you are no longer a danger to the public.
Yes, my lord.
So it may not have been the only complaint he was making, but he was certainly making a complaint based on the difference in treatment as compared with an ordinary determinate sentence prisoner.
Exactly.
And to that
Yes.
point, I think
Yes.
Lady Hale's reasoning responds, well, there is the underlying difference that a determinate sentence prisoner is by definition not one who is regarded as dangerous within the meaning of the
Yes.
Criminal Justice Act 2003.
Yes.
All right.
And finally, no doubt you'll be pleased to hear me say finally, I will take you to Lord Mance, whose reasoning starts on this at paragraph 228, and again agrees with Lady Black in the result 230, saying, just like Lady Hale, status can't be ignored. There'd be no point in the at 231, he approves the proposition that a difference in treatment does not by itself constitute a difference in status. He says that problems have arisen from attempts to extend the application of the proposition to cases beyond its scope. That's the beginning of 231. But if one can summarise what he says, well, actually, it is easy in the case of an extended determinate prisoner with a sentence of a particular type to find that relevant status independent from the treatment complained about. And the nub of his reasoning is in 236. Now, if I can pull the various points from the case law that I've taken to you, if I can pull the points together in three propositions. The first proposition, we say, is that status has a generous ambit, but it is not unlimited. It means something. It's an important separate part of the analysis. And Stock, we say, illustrates that both in the result and in the reasoning, and so too does Doherty. The second proposition is that we say the fact that there must be a relevant status independent of the treatment complained about remains a clear principle of domestic law. See Doherty. And I acknowledge that it needs to be carefully analysed whether it genuinely applies on the facts of a given case. But it clearly survives. Not only in Doherty, but also in the speeches of Stock that I've taken you to. And the third proposition is that status is in general about what you are, not about what you do or have done to you. And again, I accept that that principle is not to be rigidly applied, and that the emphasis put upon it differs from case to case. But I say it remains a principle of the domestic case law. Now, there is one final domestic authority that I should take you to, and that is Stevenson at tab 32. And the reason that I take you to this Well, my learned friend Mr. Butler relies upon it for the proposition that you can have a status based upon when you claim a benefit. And the reasoning on status is at paragraphs 40, essential reasoning is at paragraphs 49 and 50. And I might just ask you to read those paragraphs if you would, and I will then make some submissions on them. So, my lord, the first point is that status decision in Doherty, which is to completely the opposite effect. And you, my lord, being asked to choose between Doherty and Stevenson, it is Doherty, it is legislative change. And I also say that the suggestion at paragraph 50, it might be, I might be taking my life in my hands, but I think I would argue that this was decided by Owen Curian, not having a look at the totality of the case law,
But you don't.
not having a look at RJM.
But you don't know what case.
And finally on this topic, I just want to take you as shortly as I can to a handful of relevant Strasbourg decisions, which I say are illustrative of the approach taken in Strasbourg and are material to the sort of circumstances we're considering here. And the first is McGee, which is tab 42.
Which tab was that? I'm so sorry.
42.
42.
So McGee concerned a suspect who was arrested in the constituent parts of the UK. There's not always a uniform approach to legislation in particular areas. Whether or not an individual can assert a right derived from legislation may accordingly depend on the geographical reach of the legislation at issue in the individual's location at the time. For the court, insofar as there exists a difference in treatment of detained suspects under the 1988 order in the legislation of England and Wales on the matters referred to by the applicant, that difference is not to be explained in terms of personal characteristics, back to Kelson and that phrase, such as national origin or association with a national minority, but on the geographical location where the individual is arrested and detained. This permits legislation to take account of regional differences and characteristics of an objective and reasonable nature. In the present case, such a difference does not amount to discriminatory treatment within the meaning of Article 14 of the Convention. Now, I say that is an important indicator. Mere geography is not a status. Tab 44, Arson against the UK, and you may recall that this was the case in Strasbourg, derived from Carson in the House of Lords about pensions and whether you're resident in South Africa or the UK to personal status. But I just want to pick up because that is the Grand Chamber's assessment of whether there's a status in person based upon habitual residence in one country or another. And it deals with McGee towards the bottom of paragraph 70. And what it does, it doesn't say that McGee was wrong, it says that it's not comparable. So where someone is when they get arrested is not comparable. Take you to is Zammit, which is tab 46. This is, like Doherty, and indeed like Stevenson, a case about a change in a legal. So it concerns restriction on increases in rent that applied to property owners who began leasing their property before 1995, when property owners who only began after 1995 didn't have similar restrictions applied to them. It's about whether or not you could increase rents in essence as a result of a particular date being chosen. You just don't get to first base on status if your complaint is really about a change of legal regime at a particular point. And then at tab 47, there is Minter. And this is about the change in this, like Doherty actually, this is about when a sentencing regime changed, and one can see the essential background at paragraph 5, and then at paragraph 14, going over the page, one can see that Article 14 complained that after Mr. Minter had been sentenced, the sentencing regime had changed, so that for persons sentenced after the 14th of July 2008, an extended sentence was no longer available unless they had a previous conviction for a serious offence, etc. So someone in his position, sentenced under the new sentencing regime, wouldn't receive the extended sentence that he received. So this is precisely a sort of case about the differences in time that my Lord Singh was putting to me. And the court assesses that complaint starting at paragraph 66. 66 itself just sets out the basic mantras about the legal regime that the European Court uses. 67, the court goes on to say Clift doesn't support the applicant's claim, and it distinguishes Clift on the basis that this case is not about length of sentence, but about
Proposals based on other status. Is that not inconsistent with what Lady Hale was saying?
it rather depends what.
I mean, that's a clear affirmation, isn't it? I don't know which particular court this is. This is a first section. But isn't that a clear affirmation that actually the consequential treatment of different categories of prisoners, depending on their status, depending on their sentences, is other status?
Well, my lord, I think it rather depends, if I may say, two things. I mean, the first is it rather depends what flows on the difference in sentences imposed, whether that goes back to something personal to the prisoner themselves.
Whether it's independent existence of the difference in treatment. They just, in a way, they seem to be treating dates as some separate. There's no. Because when they talk about the consequence of introducing new systems, that sounds more like an objective justification type point than a status type point. It's not very clear.
Yes, I mean, I think my lady, as I said to Lord Justice Singh a few moments ago, what the reasoning in this line of case law does, and it's true of this, it's true of Zamet, it's true of this case, it's actually also true of Massey, which is referred to here, is it tends to jam together questions of status and objective justification. But I say that actually it is rejecting it on both bases, because to say no, the real thrust of this case law is you don't get to first base being status.
I know you say that, but the reasoning methodology, which we've seen now in a number of cases in Strasbourg, where, as you say, they tend to deal in the same passage with objective justification and status. That does tend to support what Lord Wilson said, for example, when he was considering the Strasbourg decision in Clift, and said that it tends to give the impression that although status has not been completely dispensed with, it's not usually, it doesn't seem to be dispositive, because what you're postulating is a scenario where it would actually make a difference, where it would actually matter, because the court's reasoning would be that this measure has no objective justification, so the difference in treatment is not objectively justified. But because somebody doesn't have the relevant status, they lose. One doesn't get a flavour of that happening.
My lord, it is absolutely true, as my lord says, that those two things tend to be run together in Strasbourg, and that is why one gets Lord Wilson saying what he said in Matteson. It's also true that Stott has reaffirmed, see Lady Hale, see Lord Mance, see the general reasoning, that status is an important part of the analysis. So maybe that there is tension in that respect between what is said domestically and what is said in Strasbourg. But again, I rely upon what is said domestically.
Well, now, what's the date of this decision? 2017.
My lord, I don't know whether I'm conscious that I've taken a lot of time doing this particular bit of the analysis. I don't know whether my lord was planning to take any 5-minute break or anything of that sort this morning, or whether you would just like me to carry on until lunchtime.
Well, I think we'll carry on.
Very good. My lord, if I can come to how we say the principles on status apply here. I will start with a couple of observations about the judge's formulation of the intra and extra local authority cohort at paragraph 78 of his judgment. So that's page A96 of the core bundle. And the first observation is the one that I was addressing with Lord Justice Singh a little bit earlier, which is that it doesn't actually meet the facts of the case, because new claims for housing benefit from existing recipients of SDP are not only about crossing local authority boundaries, and TP being an example. Of the relevant difference that meets the fact of this case is simply a person who makes a second observation, is that the fact that necessary part of the comparison or extra local authority cohort, the only difference is that one cohort stays within it.
I'm just sort of testing this. What about the difference and those where they can't be, because that was TP's position. TP had to move a significant difference.
Well, my lord, I think the answer to that is that would be postulating a different comparison, not the one that the judge has made. And indeed, one might well say that's pure speculation. But the comparison the judge has made is not one. That's why someone moves.
Well, he didn't expressly say that, but the factual scenario, all he needed to do was to add in an extra word, which is needed to move. That's all he needed. That's all that was required to put that up. And he said, well, it's those who moved from those who moved within the local authority were about
that, and what in fact what these cases are about.
You need to define, or to state the obvious, you need to define who your particular groups are in extra local authority code. Now, we have a local authority adding a hypothesis about what their medical needs are or might be is not necessary to his analysis. Would be looking at the needs of people who stay with a single local authority versus the needs of people who move over.
I'm just trying to be realistic here. We're dealing with an actual.
A difference in need is simply not a relevant part of the analysis for the distinction between them. Now, the difference in need is a relevant part of the analysis when the judge was looking, for example.
Didn't apply to him.
Yes, I mean, my lady is right. I mean, it might risk mixing up the sort of two separate bits of the analysis, however. But in fact, what the evidence was, my lord, is that SDP people are less likely to move at all because of their needs. They're less likely to move than people in the population in general. So that you don't need to rely on that, but that is an illustration as to the sort of dangers that one gets into if one starts drawing into a comparative exercise aspects that were not actually necessary or referred to in the decision. One group has moved from one local housing authority area to another, and the other group has not. He then says, in my judgment, the situation here is analogous to that in Mattison. And I say that in Mattison, as I've shown you, Lordship, an essential part of the comparison between the different groups was the fact that the different cohorts. And against that background, I have two submissions. The first is that the fact of being in the intra-local authority or the extra-local authority code true analysis, the proper comparison is simply between persons who make a new claim for housing benefit and persons who don't. And I say that because people may make new claims for housing benefit in all sorts of different circumstances, for all sorts of different reasons. And moving across a local authority boundary will be one of them, but it won't be the only one. And there's nothing concrete about using a move across local authority boundaries in these circumstances as a proxy for status, which amounts to some sort of personal character.
A status group can meet than others. It's not, one couldn't say that people who move across a local authority area are more likely to be people who have some personal characteristic.
No, my lady, and there was no evidence to that effect. So I say that really this is akin to the sort of geographical location criterion that was rejected as a basis for status McGee against the United Kingdom.
I can well understand your submission about McGee, but Northern Ireland has inherently a different legal system. Scotland does, to some extent. Does. And obviously throughout the Council of Europe there are states like the Federal Republic of Germany where there will be the different Länder. And so inevitably there are going to be different legal systems. That was the sense in which they were using geographical location, regional differences which flow from the fact that there are different legal systems in of these postcode lottery. Because they complain, they may not be right to complain, but they do complain about the fact that their access, for example, to certain kinds of health treatment may differ according to where they live in the country. Now, who's using not the actual facts of TP, but a hypothetical comparator is in principle a legitimate tool of analysis, I think. Yeah. So if somebody stays within the local administrative area of Dorset, but moves home, he doesn't have to apply for universal credit. Is that right?
Unless, as in TP's case, he has not been claiming housing benefit before.
No. Yes. Yep. But
Yes.
right.
Yes, but correct. I
Right.
mean, if you are already claiming housing
I
benefit
see.
and you're within a single housing area,
Yes. Somebody who crosses an administrative boundary must, by definition, apply for C. Is that right?
yes.
And so he
Well,
was.
if they are housing benefit claimants, my lord, and
Yeah,
they're a good lottery argument. I mean, the question is, were you in Hampshire, where you get a rather better regime than Wiltshire, where you get a worse regime at the time? I too would say that is
Well,
the
one-
essential bit of the I'm so sorry.
No, finish your.
The essential bit of the comparison for the purposes of status is geographical location. It's not.
In the two areas, some postcodes would have more affluent people than others. Some postcodes would have a higher ethnic minority demographic than others. The question is whether this is more like the date cases, the date on which you make a claim isn't likely to bear more harshly on some.
Series of trigger points, and there is an element of randomness about trigger points. I mean, in this case, it happened because there was a move across the boundary. It could happen for a whole plethora of other reasons, and indeed it could also don't give rise to a status. And the hypothesis upon which I'll answer my lady is that we are dealing with a situation in which there is nothing. I also say that a move across a local authority boundary is not analogous to the test in Carson. And the reason I say that is that the second submission is that on the judge's definition of status, what one is really looking at here is defined solely by the difference in treatment. And again, the real issue, and in other words, the status is really all about what the government has decided to do, that is, use a new claim as a trigger, rather than about a separate aspect of that's what I have to say on ground one. And I'm going to move now to ground two, status. And I will now move to grounds 1 and 3, so different treatment and objective justification, and deal with them together. And just again to map out the structure of what I'm going to do, I will start by explaining you on what we say was the wrong focus of the court when dealing with justification. We say the court looked at the wrong difference in treatment of the intra-local authority cohort who don't present fresh benefits claims at all and continue to receive legacy benefits, and members of the existing and old regime, and the new regime is a regime which the judge already found to be justified. But instead of focusing upon the fact that one judge looked at a different issue, which is whether the extra local authority cohort were provided with transitional protection, or at least whether transitional protection was considered. And one can see that very clearly from paragraphs 82 and 86 of the judgment, which are shot through with references about the failure to give any consideration to transitional protection. If I can just pick those up, that then leads on to 85, which is nothing to show that there had been consideration of this particular issue before the making of the transition regulations. And then at 86 and 87, one sees that the failure to consider any element of transitional protection feeds into then the conclusion that the difference in treatment is manifestly Now, I say, and it is a critical point, that the presence or absence of transitional protection is not the relevant difference in treatment between the cohorts. Transitional protection does not apply to either cohort. The extra local authority cohort don't get it, but neither does the intra-local authority cohort, because they simply remain on old benefits. So it's not both of which transferred to universal credit, where one received transitional protection and the other one didn't. But that's not this case. And what the focus on, you're looking at one cohort only. You're looking at the extra local authority cohort that moves across to universal credit, and you're saying, should something more have been done for them in the way of transitional protection or transitional to 87 of the judgment? He doesn't mention the comparison between the extra local authority and the intra-local authority cohort, because there's no comparison to be made. Commensurate reasonable adjustments duty into the Article 14 analysis. Another way of testing it is this. These two cohorts here couldn't be treated in the same way. If you provided the extra local authority cohort with transitional protection, you would not be treating them in the same way as the intra-local authority cohort, the non-legacy benefits, for as long as the intra-local authority cohort. And that would completely nullify the purpose of the new regime. So it shows that, I'm so sorry, yes.
I should interrupt you. Can you carry on and finish? I'll ask my question.
So it can't do that. I do say it's a really important point that the comparison it takes aim at the wrong target. Once you start looking at transitional protection, you are not
to one side for the moment. I want to put you that perhaps you're looking at the transition provisions in a way that the judge may not have intended. I'm sure about this. Not transfer to a local authority, and I'm putting to you, you may say this is incorrect, the possibility that what the judge is saying, well, you could have justified that differential by saying, as between themselves and the others. Now, I appreciate one answer to that could be, it's a different answer to the one you're giving now, which is, yes, but that presupposes you can't, this complicated arrangement in stages at which it's inevitable that some people, because that's the nature of universal credit, are going to be differently remunerated as it will paid than other people. That's a different point. What I'm really sort of addressing at the moment is what appears to be a
So that difference, and this is what I'll come to when I deal with justification, I say it inevitably flows from the fact that the judge has found that it is legitimate and justified to have a new system in place which pays less money. It is inevitable that that difference.
Obviously, the amount in their pockets is a key one and a very important one for these people. That might be one difference that you could smooth over by transition.
If I may, I might just give a bit of thought to my lady's point over lunch.
Yes, you're quite right. You slightly overrun. We'll start again.